Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukha. అందరికీ శుభోదయం. This is a case relating to statutory or compulsory registration of FIR, at least Zero FIR, as per section 173 of the Bharatiya Nagarik Suraksha Sanhita. The judgment was given by Kerala High Court. No signature or lack of signature on the complaint is not a ground for refusal to register the FIR. You have to register the FIR. Basing on section 173, which provides the legal basis for Zero FIR, Kerala High Court Justice Kauser Edappagath, actually EDDA PAGATH అంటారు, Kauser Edappagath, in the case of YY versus State of Karnataka, State of Kerala and others. This is Criminal Miscellaneous Complaint number 4778 by 2020, decided on 1/7/2025, wherein Honorable High Court clarified that registration of the FIR is compulsory in the context of email. Simply I tell you the basic facts, basic facts, you will easily understand. YY is a woman. She is staying in Australia, right? She is an Indian national, and in the year 2020, she has sent an email against or with allegations against her husband, which amounts to a cognizable offence. The complaint was sent through email. That means it does not bear her signature. She is residing in Australia and she has given a complaint through email to the DGP of Kerala State. And as usual, the office of the DGP, they have forwarded the matter, the email, to Muttam PS, MUTTOM, Muttam PS, for necessary action. Necessary action means statutory, they have to register the FIR, but they failed to register the FIR. And the reason is it is unsigned. And the person is not present in person in the police station. Therefore, they have informed her through a letter on 12/9/2020 that FIR cannot be registered because she has to come and sign the complaint. Now, coming to 173 BNSS, of course, even though this matter actually started in 2020, in 2024, you are all well aware that the new acts have come into existence. BNSS 2023, section 173 says, if any information, oral or written, relating to the commission of a cognizable offence, it has to be registered statutorily. If it is through electronic means, please remember, so it is called EFIR, in other words. So it should be taken as on record by the complainant on being signed within 3 days. That means they have to sign it within 3 days. But here the person is in Australia. What to do? Now Honorable High Court look to the other aspect, that is Zero FIR. యాక్చువల్గా పోలీస్ అంతా వాళ్ళు లేరు కాబట్టి, సంతకం పెట్టలేదు కాబట్టి రిజిస్టర్ చేయాల. కానీ హైకోర్టు విజన్ ఆఫ్ ది హైకోర్టు చూడండి. So section 173 gives statutory recognition to Zero FIR. What is Zero FIR? When the complaint discloses a cognizable offence, regardless of whether it is within the jurisdiction or within outside of their territorial jurisdiction, whether it is signed or unsigned, whether it is sent electronically or in such case also, the FIR has to be registered if the complaint discloses a cognizable offence. So therefore, the FIR has to be registered. The technical grounds, they are all unjustified and contrary to the statutory mandate of the BNSS. SHO Muttam PS should act on the fresh complaint. They are advised to give send a fresh complaint through email, and they will take it. So here, if you are a police officer, please go through, even lawyer also go through section 173 relating to the registration of the first information reports. No doubt, section 173 clause 1 says if it is by electronic means you have to get the signature within 3 days. So this might have hampered the Kerala police in the registration of the FIR, but High Court said Kerala police might have taken into consideration this aspect. Simply, this should not be so lengthy. Very simple. They should ask her to get a signature through digital signature. Isn't it? I got a digital signature. It is equal to signature. Right. So 173, please refer to previously. In our days, it was section 154 CrPC. Finally, the High Court concluded stating that, please remember, this judgment reinforces the victim-centric approach of the Bharatiya Nagarik Suraksha Sanhita. Victim-centric approach. You can't deny the FIR stating that it is not within my jurisdiction, it is within other jurisdiction. And it mandates prompt action on all cognizable offence complaints. Whenever any offence is reported, and if it is a cognizable nature, you have to register the FIR. That is what is stated in the very famous case of Lalit Kumari versus Secretary Government of the UP in 2014. Very, very important. So many case laws are there. So, irrespective of the technicalities, so the Constitution gives the power to the police authority to register the complaint. So, all the police officers, please, you are requested to look into the judgment carefully and you must register the case, particularly the Zero FIR. Okay, with this I am stopping here. Thank you very much.